Yes, I'm on page 42.
Oh, good. Okay. You testified yesterday that, in response to Mr. Biagietti, that this reflects a note, that you left a note at Ms. Marinova's house at 4 p.m. on the 27th of May. Remember that testimony?
Yes.
Even though there's no date on the note.
Yes.
And even though when you testified about this note 3 years ago, you testified that you didn't know what date you left the note, right?
Yes.
So now we're 5 years later, and your testimony 3 years ago was you didn't know when you left the note, and yesterday you do, right?
Yes, I've been staring at these notes for 3 months constantly, so.
So, Ms. Van Sack, when you were deposed and placed under oath 3 years ago, you didn't think it was necessary or appropriate to search your mind about when certain things had happened? You only did that for this jury?
So, I certainly did search my mind.
But 3 years ago you couldn't remember, but yesterday you could. 5 years after the fact.
Basically, Jessica Van Sack cannot corroborate communication with anyone except her DOC cronies. Now remember, the paper has a long-time affiliation with law enforcement scum who run the DOC and who violate the CORI privacy laws, as in this case with Gerald Jones. Now back in the day, some of you may recall Boone the Coon, and there are plenty of present-day issues of racism as well. But the court has denied any inquiry into that, so Plaintiff Marinova's lawyers cannot impeach the Herald witnesses who sit there and parade all manner of important-sounding awards before the jury, without any repercussion, without any cross-examination. Now keep in mind, I can call bullshit on all these people, as well as the governor, Governor Patrick, as noted in another short video that I did last week, and I've earned that right. Not only was I a law enforcement attorney, I then successfully sued the state on behalf of citizens and former law enforcement. I've forgotten about some of these cases. Take a look at the one I won on appeal for retired police officer Gerald Michael, 134 Ohio Ave 3rd, 7/19, 1999. Not my first time in this fucking rodeo.
Okay. I actually wanted to go back to some things. I think I found what I was looking for. On your chart, Exhibit 88, can you please identify for me on this chart, Trial Exhibit 88, where there is reference to a telephone call on May 11th to Mr. Lyman?
I never said it was a telephone call from myself to him. I don't recall who called him.
Okay, well then let's look at Mr. Lyman's cell phone records. Where on May 11th, in Mr. Lyman's cell phone record, is there a telephone call to you?
I don't know where.
I can represent you, Ms. Van Sack, but please do check that I couldn't find any telephone records of Mr. Lyman calling you on May 11th. So just so we're clear, May 11th, conversation with DOC source number 2, you don't have a cell phone record of yours, and you don't have a cell phone record of Mr. Lyman, which supports the fact that there was a telephone call. No, there is no record.
No, there's no record. It's been on a different call.
Have you gotten the disciplinary report?
It could be. I don't know.
You don't know.
I don't know.
Well, at some point, whether this, and I think you testified yesterday from questions from Mr. Biagietti, that when you got the disciplinary report, it was confirmation of reliability as to what your source had told you.
Yes.
Even though the D report didn't support that there was a hand job or the conduct was way worse, right?
No, what Mr. Kenaway was saying was that the incident was actually way worse than what was written in the D report.
And then you saw the D report, and it didn't make any mention of anything which would suggest a hand job, right? Let's go to page 643, okay? This is a note that you took after the article was published.
Yes.
And instead of referring to confidential source 1 or confidential source 2, you just write Mr. Kenaway.
Yes.
So he was an on-the-record source for certain parts of your story and a confidential source for others?
he had, at that point, if I recall correctly, already given an interview on the record to the Boston Globe, and I asked him to extend me the same courtesy.
Okay. And so he was a confidential source for you on May 28th, but on May 29th, he was an on-the-record source for the same story. Yeah.
No, sir. I don't know which date this note was written.
Oh, sometime shortly after May 28th, he was an on-the-record source.
I wouldn't even go that far, sir, because I don't believe that this ever made its way into an article.
Okay. Well, then let me ask it a slightly different way. Prior to May 28th, he told you you couldn't use his name as an on-the-record source.
That was our understanding.
And then after May 28th, he told you you could.
At some point after May 28th, he gave me permission to use the following statements attributed to him on these pages. On this page, they gave him a deal that
Okay. Now, this note says they gave him a deal, right?
yes.
And you would agree with me that when you were asked under oath 3 years ago about whether you had an understanding as to what Mr. Kennaway was referring to, you said you didn't know, right?
I don't recall. I have to look at the full context.
All right, why don't you, let's take a look quickly at page 265 and 266.